It should be striking to people that 50 years passed between 1870 and the passage of the 15th Amendment, guaranteeing the right of men to vote and not women, regardless of race, color, or previous status of servitude, and the 19th Amendment, which guaranteed women the right to vote. But that period of time between 1870 and 1920 wasn't a time where men of different ethnicities from the dominant majority of Caucasian Americans enjoyed equality and rights equal to those of their white counterparts. So let's take a moment and go back and look at the rise of civil rights in the United States. So people normally think of the Emancipation Proclamation, which was issued in 1863, as the end of slavery in the United States. However, it's actually the 13th Amendment to the Constitution that provides the federal prohibition against slavery. Now, Lincoln issued the Emancipation Proclamation as an executive order, that is, as an exercise of his powers as Commander-in-Chief of the Armed Forces, according to Article 2, Section 2 of the Constitution. However, there were concerns that the proclamation freed slaves but didn't prohibit slavery, and that it might be construed as applying only during the Civil War or only to those states that were part of the Union at that time. And this prompted abolitionists to forward the 13th Amendment. Now, the 13th Amendment passed the Senate in 1864 and the House in 1865. And it reads, Section 1, neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist in the United States or in any place subject to their jurisdiction. Section 2, Congress shall have the power to enforce this article by appropriate legislation. After the passage of the 13th Amendment, during the period starting in 1865 and going into 1866, many southern states sought to sidestep the prohibition against slavery by creating laws that restricted the freedom of blacks and compelled them into low-wage or debt work, ultimately laws that would sidestep the 13th Amendment to try and recreate the slave codes. The ultimate goal of these laws, which were often called the Black Codes, was to recreate the slave codes in a manner that couldn't be challenged in the 13th Amendment. Now, in response to this, the federal government passed the 14th and 15th Amendments, as well as the Civil Rights Act of 1875. Now, the 14th Amendment, which was passed in 1868, guarantees citizenship and equal protection under the law to all people born in the U.S. or naturalized to the U.S. citizenship, as well as equal protection for all people while in the U.S. It has 4 sections. And the first one reads as follows. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Of course, the 15th Amendment guaranteed the right of voting. And then Charles Sumner and Benjamin Butler introduced in 1870, but didn't pass until Sumner had died, the Civil Rights Act of 1875. It provided for equal treatment in public accommodations. However, it did little to thwart legalized discrimination and the growing segregation. Since 1870, white Democratic politicians have returned to power in the South through legitimate and illegitimate elections. And starting around 1876, politicians began to pass further extend the first of the Jim Crow laws as replacements for the Black Codes that could sidestep the 14th, 15th, and 1876 Civil Rights Acts. These laws restricted voter registration and voter eligibility through the imposition of additional requirements on voting, including things like literacy tests. These voting laws affected blacks and poor whites who were disproportionately illiterate. Federal troops withdrew from the South in 1877, and parts of the 1875 Civil Rights Act were declared unconstitutional by the Supreme Court in 1883. And these things resulted in a widening scope for Jim Crow laws to include more types of segregation and discrimination. In 1896, the Supreme Court adopted the separate but equal doctrine in Plessy versus Ferguson, which further emboldened segregationists in crafting and passing Jim Crow laws. So far, we've discussed civil rights in the South. People usually think of the Jim Crow laws as laws enacted during the period between the passage of the 15th Amendment in 1870 and the passage of the Civil Rights Act in 1964 and the Voting Rights Act in 1965. However, I'd encourage you to consider them as laws defined by their general intent. And their general intent is to deprive a class of people of civil rights and the opportunities provided to most citizens within our society. And thinking of them in this way, and not in their historical context, I think helps us to understand and encourages us to view these laws as part of a wider history of institutionalized racism affecting many ethnicities, genders, and sexual orientations within the United States. Though often portrayed as Southern laws aimed against blacks, 41 states had versions of laws that were like Jim Crow laws, and that they instituted legal segregation, denied voting rights, prohibited or restricted interracial marriage, and they applied to blacks, to Native Americans, to Asians, and to Hispanics. For instance, Arizona passed a law declaring illegal and void all marriages between whites and, in quotations, their terminology, Negroes, mulattoes, Indians, and Mongolians. In California, in 1870, they passed a law mandating that blacks and Native Americans attend separate schools. California amended the Constitution in 1879 so that Chinese people could not be hired by corporations or public works, could not vote, could not contract for their labor, could not be, to use the term in the Constitution, imported. It also imposed restrictions on their residency. And if you have a little time, and you want to know a little bit more about California at that time, I encourage you to follow the link on the syllabus that takes you to a copy of the 1879 California Constitution. It is a pretty despicable document, to be perfectly honest. In the next lectures, we're going to turn our attention to legal and civil actions taken primarily in the latter half of the 20th century that ultimately led to legal prohibitions that largely prevent the kinds of laws that are characterized as Jim Crow laws at the federal level in the United States.